Good evening. My name is Harry Shipley. I'm the Assistant Executive Director here at the Bar Association. I'd like to thank each and every one of you for attending this evening. Tonight is our first People's Law School, and our hope is to have, at a minimum, a quarterly law school to invite the public to come and learn more about the law. And if it's successful, as this evening appears to be, we may be doing this on a monthly basis. We'll see how what time permits and what you provide us for feedback in order to continue to expand our series. One of the reasons that we decided to do a People's Law School is we do understand that the law can be confusing and at times frightening. And we hope that after you have these two great presenters, it will be a little less frightening what you might have ahead with your legal issues. So our first series was going to be older Iowans issues, and that's what they'll be talking about this evening. But a couple housekeeping items before we get started. First and foremost, restrooms right outside to your left. If you need to get up, feel free to get up, and we also have refreshments and little snacks over there, because we do know that we're cutting into dinner time at this point. So with that, the last thing I have to share is in your packet of information, you do have an evaluation form. We would really appreciate it at the conclusion of tonight's event if you take the time to fill that out. That will help us determine how we can make this a better event, and perhaps what topics we need to cover in future editions of the People's Law School. With that being said, I'm going to have Virginia Sipes come up here and introduce your two speakers, and we'll get started.
We are so thrilled that you're here, and I just gave away my booklets that had the phenomenal information about Craig and Deanna. So we are so thrilled to have you here tonight. Thank you for coming out. So let me tell you a little bit about these amazing people that also made this possible tonight. Oh, I should grab a microphone. Yeah. So let me tell you a little bit about Deanna Clingan-Fischer. She is an Ombuds officer at Iowa State University. I think you are the Ombuds officer at Iowa State University, and she has served as the state's long-term care Ombuds person from 2011 to 2017. She worked as a legal services developer for the Iowa Department on Aging before that, and she worked on issues related to powers of attorney, living wills, guardianship, elder abuse, long-term care facilities, and Medicaid managed care. She has done phenomenal things for the Iowa State Bar Association, including being president of, past chair of the Young Lawyers Division. I think also president. Yes. No? Okay. Services to the Elderly Committee. She is a member of the ISBA Elder Law and Probate sections, as well as the 2007 recipient of the National Aging and Law Award for her contributions to justice for older persons. And we could not thank her enough. Greg Kenyon, also, we could not thank him enough either. He is a regular speaker and presenter for continuing legal education on estates, trusts, elder law, Medicaid, and long-term care planning. He's with the firm Bradshaw, Fowler, and Proctor and Fairgrave in Des Moines. And I put an extra "and" in there, forgive me. But if you need to find him, he's past chair of the ISBA Elder Law section and the Probate and Trust section. And Mr. Kenyon is also a member of the Elder Law, Probate, Trusts, and Estate Planning sections. And he, you may have seen him on TV or heard him on the radio as well. So we are grateful for that. I wanted to let you know, is that Mr. Carroll, that we also have some people that are here that you might like to get to know as well. Anthony Carroll is the Associate State Director for Advocacy for the AARP of Iowa. Hello, Anthony. And then we have another phenomenal person from Aging Resources of Central Iowa. Here she is, Kay Vonix. And also we have Barb McClanahan. Barb, are you in here as well? Oh, that's you, Barb. Forgive me. Okay. She's volunteer coordinator for the Alzheimer's Association. And if you didn't get a t-shirt, there are t-shirts here for you, courtesy of the Alzheimer's Association. I wanted to let you know as well, in case this is a concern for you, we are recording this event so that we may be able to share it in the future with other people if it's easier for them to see it online. If you have any concerns about that, just come over and let me know. We are taking some photographs, but we're trying to be very respectful about, not getting up in your face or things like that. So, but if you have any concerns, you just let me know and we'll help you out. So thank you so much. Without further ado, here's the information that you came for. Thank you for coming out. Thank you.
Thank you, Virginia. Thank you all for coming. We hope that you'll find this to be helpful. And for those of you who learned about this from watching the spot we did on the TV, and you saw me on there and you came anyway, so thank you. Deanna and I have presented, come on in, have presented before, and actually we could probably take turns doing this part, but we broke this up and I'm going to start off and then Deanna's going to take over and then we'll kind of go back and forth. Our goal is to cover the topics 15 to 20 minutes on each of the main topics and then leave time for questions. So we want to do the questions at the end, so if you think of something, jot it down. We think that it'll flow a little better that way. So we're going to talk in general about fiduciaries. I'm going to talk about financial power of attorney. Deanna's going to talk about the healthcare power of attorney and living will. And we'll both talk a little bit about the final Disposition Act. So that's kind of our battle plan here. A fiduciary, and this will be helpful when you think about it. A fiduciary is a person's in a position of trust. So if you ask somebody to do something for you, whether it's a power of attorney, it could be a guardian, it could be an executor of an estate or a trustee. Those are all fiduciaries, and they're held to a position of trust, and they're supposed to act in good faith for the benefit of that person. In fact, there's a law school case that describes a fiduciary's role as being the punctilio of honor, which is the highest degree of honor that you can give. That's what you're charged with when you're serving as a fiduciary. So you're going to be a person that manages property for another person or helps them make personal decisions. The healthcare agent, and we call it an agent, the person that is the individual that signs the document is the principal, and they appoint an agent to make those decisions for them. That agent must act consistently with the desires of the principal as stated in the document. So the document is always our guiding light. It's our pole star, another law school term. So fiduciaries generically include an attorney in fact or an agent. That could be either a financial agent or a healthcare agent, a representative payee under the Social Security Act when you help somebody that's got Social Security that can't handle their own finances for health or other reasons, an executor or an administrator for an estate, guardian makes the decisions for an individual. That's a court-appointed role, as is a conservator, and a trustee. These are all fiduciary roles. So Deanna and I may talk about fiduciaries, and it includes all of those things. And so if you think of those generically, and we worked together on a task force years ago to create what was called Substitute Decision Makers Office in the state of Iowa. All of these would be substitute decision makers because you're standing in for the initial person. So if you think of it that way as a stand-in. For the baseball fans out there, I always think of it as the relief pitcher. You start the game and then you go to the bullpen and you get a relief pitcher. All of these people are relief pitchers and they're fiduciaries in that role. So we're going to talk now about the financial power of attorney in some detail. Our statute in Iowa was changed very recently. Until 2014, we really had very little statutory law on a power of attorney. It relied on what had grown up over time, what we call common law, just the things that people got used to doing. But in 2014, a statute was passed in the state of Iowa, which really set forth in black and white what the power of attorney does and what their responsibilities are. So what I've got here are some questions that we prepared when we were doing that legislation to talk about what a financial power of attorney is. It's a document, again, the principal gives authority to someone else to make decisions about his or her financial affairs, and it can be any number of things. I'm going to not get ahead of myself, but the person that then serves is called the agent, okay? So that's a very basic thing to start with, principal and the agent. Historically, a power of attorney the agent under the power of attorney could only do what the principal could do. So you think of it almost as a shadow, okay? So if the principal could write a contract or enter into an agreement, the agent could do that for him. So that's the history of that. What grew in recent years, and recent is a relative term in the eyes of the law, but let's say 25 or 30 years, is the idea of a durable power of attorney. A lot of you probably heard that term. Here's why that's important. So if the agent can only do what the principal could do, what happens if the principal has a stroke? Can't sign a contract, can't make decisions? Well, that agent could not either. So the very time that you might need that power of attorney, it was not of any value. So the concept of a durable power of attorney came into being, and that's the way our law reads now. It's a durable power of attorney unless you say otherwise, and it continues. So you set this person up to be the agent, and they will act on your behalf, and they can continue to act on your behalf even if you become disabled. In fact, some people draw up these documents to be triggered to go into effect on that disability. A standby or a springing power of attorney, sometimes they're called. So that's just a little bit of background. When you hear the term durable power of attorney, that's what the significance is. What is the benefit of having a power of attorney? When you think about it, all of us have probably known somebody who's been in a situation like this. You're planning for a potential incapacity or inability to manage your affairs. So you're appointing somebody to take care of these things when you cannot. And it could be as simple as something like, I know I'm going to go in and have surgery and I'll be incapacitated for a month or so while I'm rehabbing, and I want somebody else to handle my affairs during that time period. Or it may be more permanent, where you recognize as you get older that you may not be able to handle your affairs forever, so you want to name the person that will carry on for you. Some people do this when they go on trips. They'll name somebody to handle their business affairs while they're gone. So this is a stand-in for you during this period where you might be unable to conduct your own affairs. In contrast, okay, if a person doesn't have a POA, what are the options? Well, in Iowa, you can get a court-appointed substitute decision maker or fiduciary. That's a guardian or conservator, and it works just fine, but you have the court supervising it. And some people find that to be a good thing, and some people find it to be a bad thing, but you do have the court involved then in the decisions, and there's the inherent red tape in having a court involved. There's reports that are due. There's the cost of going to court to have it established, all of which can be daunting. And so if you can take the time to plan ahead, you will save that expense for your loved ones, whoever they may be in your family. One of the things that the Act was intended to cover was the fact that there's been abuse of these agency agreements. And you read these stories once in a while where someone who has a power of attorney for a parent runs amok. They spend all their time at Prairie Meadows and burn through all the money of the parent. And we have attempted in the statute to try and address that. But the key thing is that the person is a fiduciary. They're not supposed to do that. And the principal should be only naming someone that they feel very comfortable is not going to be that kind of person. Sometimes you feel like you're trapped. I have 3 children and none of them are in Iowa. And so who do I name to be that agent? Or, this is a little bit of a joke when I say this, but you go through the choices with your client and they say, well, one of my children lives overseas, so they're not really a good candidate, and my son lives in Kansas. Could he do it? Well, yes. There's no requirement that they live in the state of Iowa. That's okay. What's his address in Kansas? Because I'm going to put it in my notes. Leavenworth. Where do you mean Leavenworth? Well, I think in that case, this is probably not a real good choice for us to name as a power of attorney. Now, things are not always that black and white, but the point is you want to select somebody that you can trust that will do the right thing. The stories that you will hear about where there's abuse, and we get 1 or 2 of these a year that usually get publicity. Inevitably, the parent may have some decline in capacity, dementia or Alzheimer's, and the child seems to be using the money for their own purposes and not for the benefit of the parent. If that happens, they can be brought up on charges of elder abuse. They can be jailed for embezzlement. It doesn't happen often, but it does happen occasionally. And we are seeing more efforts to crack down on that. The Attorney General's office right now has a group that they've convened called the Coordinated Community Response, CCR, and they're trying to create a network so when people see something that they think might be abusive, they have a place to call in and have someone act on it. Law enforcement, Department of Human Services, Department of Aging, there's a number of stakeholders involved in this group, and it's intended to address that issue. What I would tell you is that I do them all the time. I can't tell you that I do 1 or 2 a week, but on average I probably do a couple a week, so 100 or so a year, and I've been practicing longer than I care to remember, so thousands of these documents we've done, and I don't remember a time when I've had one of my clients have a problem with a bad power of attorney, but there are occasions when it does occur. The legal requirements, it's got to be a signed document by the principal, and it's got to be notarized. There are instances where the individual does not have the physical ability to sign because of a physical injury, or maybe they're paralyzed, they can't use their hands. It's okay, they can orally okay it, and somebody can sign it at their direction as long as it's duly notarized and witnessed. That can make it official. You can have it be effective immediately, as I mentioned, or it can be spring into effect at a different time. And this is the part about the durable, this first sentence. It remains effective if the principal becomes incapacitated unless the document says otherwise. Okay, so it's a continuing and durable document. An important point that people don't always think about is that that POA ends when the document says it ends, or at the death of the individual. Remember how I said the agent can only do what the principal can do. Well, if the principal dies, the agent can't do anything. So you get these questions periodically. I'm the power of attorney for my mother. She just died. Can I get into her bank account and write a check? Well, the answer is probably no, unless you're on the account in some other capacity, because the power of attorney ended at the date of death. Who can serve as an agent? Any individual that's of legal age, and sometimes you can get a corporate entity like a bank to serve as a power of attorney. They don't do that a lot, but they'll do it sometimes. They don't have to be a relative. They can be a good friend. But again, it ought to be somebody that you trust. Here are some of the traits. They look a little bit like a Boy Scout when you list what the traits would be. Girl Scout, I'm going to be gender specific here. Trustworthy, knowledgeable and experienced about financial decisions, willing to take on the responsibility, available to do the work, located reasonably nearby. And that, in today's world, is not as critical as it was years ago because of all the means we have to communicate instantly, but it's still preferred, certainly, to be nearby. They're willing to carry out the wishes of the principal and not their own, and sometimes people get those things confused. They're able to manage conflicts because inevitably, if you're a member of a large family, there will be other children who have different ideas about how you should be spending mom or dad's money. The documents allow you to shift into a guardianship or conservatorship. The current form that came out of our new act, you can include a clause that says, if for some reason this power of attorney is not enough to get the job done, I nominate the same person or somebody else to be a conservator, and now I get a judge's order, which is more powerful, and they can get things done. Here's an example of when we sometimes encounter that. You might be dealing with a stock in a publicly held company. So think Principal Financial Group, and that stock is traded over the exchange, and you want to sell that stock. They may say to you, we're concerned that power of attorney may not be current, and we would rather have a conservator appointed, and say they may compel you to have a conservator appointed to get that done. We try always to finesse our way not to have an appointment made if we can get it done with the power of attorney. And one of the things that comes out of the Iowa statute on this is that when big brokerage houses or banks refuse to honor a power of attorney that's otherwise valid, they can be held responsible for the cost that you incur in getting the thing straightened out. So we call it a carrot and stick when the law was passed, that we say to them, if you will honor this power of attorney, you are not responsible for any liability for honoring that power of attorney. However, if you refuse to honor that power of attorney, we can go to court and get an order that says you should have done that, and now every nickel that we spent in getting that order, the attorney's fees, the cost for both parties, whatever it is, they're on your head. We find that that gets the attention of the bankers, and then they will cooperate with us. Not always, but usually. The document, you can name a succession of people, so if the primary person is unable, you've got a backup. It's my baseball analogy again. If the first person can't do it, you go to the bullpen and you call somebody else up. You're next in the lineup. And that successor is going to have all the same powers as that first agent unless you specify otherwise. There's a list of things in the code that an agent can do, and it's very, very lengthy. In the statutory form, there's a list of things you can check and says either yes, I want this, or no, I don't, or all of the above. And then there are additional provisions you can add. So it can be an exhaustive list. In our office, we have our own document we've created and modified over the years. We include in it everything we can imagine that that agent would have to do. There are certain things that you have to have specific language in the trust to authorize the agent to do. And this is one I'm not terribly comfortable with, but the law allows it. The agent can create a trust for the benefit of the individual. So there could be an occasion where it's the right thing to do to create a trust for the principal. It's, again, the principal's money, and you're going to create the trust for the benefit of the principal, not for anybody else. You can also give them authority to make certain gifts. Might be gifts to charitable organizations that they've been in the habit of doing, like your church tithing or annual Christmas gifts, that sort of thing. You can also give them other power, what's called a power of appointment in a estate plan. So certain things you have to specifically list. The duties are listed in the code, but they're limited, or they include but are not limited to acting. This is the most important thing. You're acting in accordance with the principal's reasonable expectations, if known, and if unknown, in their best interest. So you're always supposed to act in the best interest of that individual. You can challenge that POA if somebody you think is doing things they're not supposed to. The list of people that can bring that would be a person who has sufficient interest in the principal's welfare. That might be a spouse, it could be a child, it could be just another friend that brings that to the attention. You can bring an action then to have their activities and transactions examined. If they have done things they shouldn't have, they can be held personally responsible. I'm going to skip that because we kind of talked about it. The power of attorney form, the standard form that the bar uses and that many lawyers use, is going to be accepted most places. We find that some banks or financial institutions will have their own form. And this can be a challenge because you create this document, and when you're using it, the principal is disabled a lot of times. And so the bank will say, well, this is great, but we want to use our form. Well, you know, we can't get one signed because the person can't do that. And so then again, we may have to go to court and get an order compelling them to honor that. The Internal Revenue Service has their own power of attorney form, and fat chance getting them to accept anything that they don't want to take. But that's an example. And this is where I get to transition to Deanna, because shortly after this thing, this is about my last slide. The Power of Attorney Act that I've been talking about deals exclusively with financial things and not health care. We have a separate statute that deals with health care. The Financial Power of Attorney Act appears in Chapter 633B of the Iowa Code. And the Healthcare Act, all of these healthcare things we're going to talk about, the healthcare power of attorney, the living will, and the dispositions are all in Chapter 144 A, B, and C. We had our thinking caps on when we put those together in the same place. There is a standard form to create the power of attorney. You're not required to use it. Many law firms have their own document that they customize to meet your needs, but the statutory form is intended to be available for people to use. Unlike the healthcare power of attorney, which is very direct, you know, I'm appointing this person and then these are the decisions. The financial power of attorney entails many more decisions. And so, to my knowledge, we don't put that available on the website for just regular signature. Am I correct on that, Dwight or Harry? Somebody correct me if I'm...
That's correct.
Okay. If you did a power of attorney before our law was passed in 2014, that power of attorney is still valid. The fact that we got a new statute didn't change that. Okay? Over to you, Deanna.
Thank you, Greg. Well, it's my pleasure to be with you today. I'm happy to talk about something that's near and dear to my heart, that of healthcare powers of attorney, living wills, taking care of your person. So let's start with some basic definitions. Greg already stole my thunder a little bit on the principle thing, but you know, you need to hear it multiple times to retain it, right? So the principal is the person that signs the document. When I worked with folks on this, a lot of times people would always say, my power of attorney said this, or my power of attorney is going to do that. So I always like to distinguish. The power of attorney is the document. The person acting is either your attorney in fact or agent. I knew what they meant, and I never corrected people necessarily, but I think in trying to share this with you, you need to know what the terms that are used should be. So the principal, that's you. If you're signing the document, you're the principal. If you are appointing me to act on your behalf when you cannot, then I'm your attorney in fact or your agent. Durable is that word that Greg alluded to that means this document survives my incapacity or my disability. And that's what most people want. You know, when I talk to people about this, I say, what are your goals for this document? Is it just, are you filling it out because someone said, hey, you need a power of attorney and you better do it? I mean, that's one reason, but another reason is to really think about what are the options when something happens to me and I can't make these decisions for myself. The healthcare power of attorney, unlike the financial power of attorney, only takes effect when you cannot make decisions for yourself. All right? So it stands in waiting. The people don't have a role or a responsibility. The attorney in fact or agent doesn't have a role or a responsibility until that point in time where you can't make decisions for yourself. All right? The financial power of attorney can take effect immediately or at some point in the future. So that's one of the distinctions and differences. Just because you've appointed me as your attorney in fact doesn't mean I can go around telling you what to do. And a lot of people try to do that. You know, well, I'm her attorney in fact. Okay, well, can mom make decisions for herself still? Yes, well then she should be. It's not your role yet until she can't make those decisions. So durable ensures that if your goal for a healthcare power of attorney is to ensure that someone's available to make those decisions when you can't, it should say durable, or it should say something to that effect that this document survives my incapacity. So what is a healthcare power of attorney? A healthcare power of attorney or a medical power of attorney is a document where you're giving someone else the authority to make healthcare decisions for you, as I've stated multiple times now, when you cannot. All right? It's when you cannot. They are to make decisions according to your wishes, not what is convenient, not what's in their best interests, not what the doctor's telling them to do, or what the other kids are telling them to do, but what you wanted. If they don't know what you wanted, they have to act in your best interests. And a power of attorney for healthcare does take priority in decision-making over a guardian. So you really shouldn't necessarily need to go through the guardianship route, which is through the court, and if you have a validly executed power of attorney. This is my little sidestep here. Powers of attorney are great tools. They're great tools, and for anyone who wants to be able to direct who makes decisions for them when they cannot. You know, it's like an insurance policy. I bet most of you around this room or in this room have some type of insurance policy. Healthcare, homeowners, car insurance. Do you want to use them? Not necessarily. Do you want to make a claim? Not necessarily. But you've got them. And that's kind of what a durable power of attorney for healthcare is, or a living will. They're documents that you sign so that you can have control over what happens to you, ultimately. If I appoint my son as my attorney in fact, the piece I'm missing, if I just sign the document and appoint him, is the conversation or the communication, all right? How is my son gonna know what my wishes are if I don't have a talk with him about, hey, in this case, I would like this done. In this case, I don't want that done. It's a conversation. If you just sign the document without that conversation or without the thought process before signing it, you're missing the effectiveness of this tool. My son cannot act according to my wishes if he doesn't know what they are, right? And then it can become subjective. What is in my best interest? Is it to keep me alive when there's perhaps no hope of recovery? Or is it to let me go? And is that based upon emotion or medical evidence, right? So those are the kind of things that you really need to talk through. I try to talk to my husband about this quite often, and he's like, oh, I don't want to hear it, you know, because he's got to imagine a time that's going to be difficult, where he's got to make some decisions for me that he's not going to be comfortable making. But I'm trying to make it as simple as possible for him. Same thing with my parents. You know, my dad has passed away, but with my mom, well, before he passed away, I would always talk to them about, what is it you want? I was that kid always bringing it up, not because I wanted the authority or the power, but because I needed to know what they wanted, because I knew what the law said, right? And they would always say, oh, honey, you don't need to worry about it. You don't need to worry about it. We don't want you to think about that. And I'm like, I don't want to think about it either, but I've got to think about it because I want to ensure your wishes are honored. And it's a very difficult conversation. I've talked with older people throughout the years of my working as an advocate for older folks that, you know, some people say, we have it around the Thanksgiving table. It's like, okay, what am I thankful for? I'm thankful for my health. But if I didn't have my health, here's what I'd want. So those are some examples of how to maybe bring it up if you get resistance. But you know what? If you get resistance, maybe that's not the person you want to appoint. Because you have to think back, are they going to be able to implement my wishes? There is a book called The Gift of Peace of Mind. It is on the list of websites that I've given out to you, and I did bring a copy of it. I have the old version copy. It's that pink one there, Greg. Thank you. This is the old version. There's a new one that looks like this lengthwise, and it's blue now. But the old one, what I like about this book, and what I recommend people do is to look at, there's a table inside of it, and you can get to it from that website that's on your sheet. What I recommend people do is they go through this worksheet and they attach it to their document, or they at least go through this conversation with the person that they want to appoint. One example. A is if my doctor determines that I have a condition that will shortly cause my death. Do I want CPR? Do I want mechanical breathing? Do I want artificial nutrition and hydration, so water and food through IVs? Do I want pain medication? My answer to that is yes, please, right? There's never a reason just because you determine not to have a course of treatment to not have pain medication or have comfort care, okay? But again, the beauty of this is it's your call. It's up to each of us to make that determination. What I want is not what you want or what you want necessarily, and that's okay. This is about individual choice. Or do I want antibiotics? So if I get an infection and I'm already in the process of dying, do I want to treat that infection? All right? So another example is I'm healthy. I walk out the door and I'm hit by a car. And I'm unconscious. But the likelihood of me getting better is good. So am I going to want something different in that situation? You know, for me, the answer is yes. So if I tell my son I don't want any type of life-sustaining procedures, what does that mean in each situation, right? So the nice part about this book, it guides you through that process. The American Bar Association has a similar type of checklist on their website, and I've provided that website for you as well. So it's just, again, think about it. Don't just sign the document, but really put some thought into it. And it's difficult, I'm not gonna lie. It's not a fun thing to think about, but it's a necessary thing to think about. So what do I have to do to have a valid power of attorney for healthcare? Durable power of attorney for healthcare. I have to have capacity, be 18 years of age or older. So that's the key. You need to sign these while you can. Once you lose capacity, you can't sign it. And you will probably have to go the guardianship or the conservatorship route, which goes through the court process. And you have to be competent. So in Iowa, you're not competent if you have a guardian or a conservator. So if you have a guardian or conservator, you cannot now sign it. Perhaps with a conservator, you could sign the healthcare power of attorney form if you've not been deemed incompetent on healthcare. But that's what the competency means. So the key piece that you should take away is sign it while you can, if you're so inclined. It has to be in writing, handwritten, typed on the form. The form for healthcare power of attorney is on the Iowa State Bar Association's website. So you can get just the medical power of attorney form, you can get just a living will form, or you can get the combined form. And it has to contain the name of the person you're appointing as your attorney in fact or agent. What are the powers, the duties, the responsibilities you're giving to them? You, as the principal, have to sign it, date it, and you have to sign it in front of, and that's the key, in front of. Don't sign it and then go, hey, Greg, would you notarize or witness this? You need to sign it in front of the notary or two witnesses. But alas, we have conditions on who can be a witness. So a healthcare provider attending you on the date you sign it cannot be a witness, and an employee of the healthcare provider. You should not have the attorney in fact be a witness, someone less than 18 years of age, and at least one should be a non-relative. So we don't get into that fighting about, well, you know, you forced mom to sign that, or you forced dad to sign it. Let's get an independent party to also be a witness. If you're going to go the witness route, you need two witnesses. Who cannot be an attorney in fact is, again, the healthcare provider that's attending the principal, or an employee of the healthcare provider, unless that individual is related to the person, to the principal. Who should have copies? I say anyone and everyone. Because guess what? If nobody knows it exists, it doesn't, right? Nobody knows where to go to get it. And you shouldn't put it in your safety deposit box. Because upon death, or upon incapacity, you just heard, you know, if you don't have that financial power of attorney form, they can't get into your safety deposit box, perhaps. So, unless it's been activated. They might be able to, but the person who's your attorney in fact for healthcare may not be the one that can access the safety deposit box. So give copies to your attorney in fact, to your medical, your healthcare team, your professionals, to family members, friends. Certainly you should keep one for yourself, but make it accessible, easily accessible. You know, like it's in my top sock drawer if you need it, that type of a thing. I always say to people, who's going to be the first one that's contacted if something happens to you? They should have a copy. That could be a best friend. It could be a neighbor. It could be your minister, your pastor. You know, think about it like that. You can revoke a power of attorney for healthcare at any time. You can do it orally or in writing. But of course, you need to tell the people that you've given all of these copies to that you've now revoked it. It could also be done while someone's delivering healthcare to you. You know, I don't like the decision my son is making right this moment, so I'm going to say, I don't want you to act as my attorney in fact anymore. And so then the doctors will start listening to me. And it does terminate upon disability or incapacity unless it's durable, but it also terminates upon death. So the power of attorney for healthcare cannot start planning your funeral or make decisions about your healthcare or your body after your death. There's an exception we'll talk about at the very end. So just issues to consider, you know, don't put it in your safety deposit box. Other states do recognize it as long as it's validly executed in Iowa. The forms are available at the Bar Association's website, but there is no court oversight. So back to Greg's point, you better appoint someone you trust, right? You need to communicate your wishes with the person that you want to appoint. I encourage people to think about nominating an alternate. So when my older son is in the military, if he's not here and he's deployed overseas and he's my named attorney, in fact, it's going to be very difficult for him to make that decision. So I need to have someone as an alternate that they can go to. The other key piece that you need to think about is don't just think of it as a gift. Like my son would love to serve as my attorney. In fact, I just know it, right? So I'm going to appoint him, but I don't tell him. So what happens if this document is then needed and he says, I don't want the duty? He can say, I don't want to do it. So that's the other piece about communication is talk to the folk that you're thinking about nominating to ensure that they feel comfortable taking that role on. It can be a lot of work and it can be a lot of emotional stress in some situations. So make sure that that person will take that job on and honor your wishes. The living will, so the power of attorney for healthcare and the living will are things called advanced directives, if you've heard of those words. Advanced directives are your durable power of attorney for healthcare and your living will. So with the durable power of attorney for healthcare, I'm nominating someone else to make healthcare decisions for me when I cannot make those for myself. With the living will, I'm not nominating anyone. With the living will, I'm telling my doctor, I'm telling my healthcare professionals that in the event I'm in a terminal condition, which in Iowa includes persistent vegetative state, I do not want life-sustaining procedures applied, okay? But a living will only takes effect when you're diagnosed as terminal. And it's a directive to medical staff. You're not appointing anyone else. Now, ideally, if you have a living will, your attorney, in fact, is following those wishes, okay? A life-sustaining procedure. Now, remember, living wills only take effect if you're terminal, and it's about life-sustaining procedures. It means that certain life-sustaining procedures will be withheld, or if they've been started, they will be withdrawn. All right? So what's a life-sustaining procedure? It's any medical procedure, treatment, or intervention that uses mechanical or artificial means to restore, sustain, or supplant a spontaneous vital function. So think CPR, think a breathing machine, think IVs that give you food and water if that's a life-sustaining procedure, and it is under Iowa. And the key here is it's only going to prolong the dying process. So I'm already in the process of dying. I might live another day, another week, another 2 months if you intervene with life-sustaining procedures. But ultimately, I'm going to die of that condition. And a terminal condition is an incurable or irreversible condition in which I will die within a relatively short period of time. It's also a comatose state from which there is no recovery to a reasonable degree of medical certainty. That decision as to who has a terminal condition is made by an attending physician and then seconded by another physician. Okay, and then that's written in your medical report. So you make a living will about the same way you make a power of attorney for healthcare. You've got to be competent. You've got to be understanding what you're signing, 18 and older. It has to be signed, and in this case, we're going to throw in another word, declarant. So the person that signs a living will is called the declarant. You'll sign it, if you're going to do this, in front of either 2 witnesses or a notary. It has to be in writing and it has to be dated. Again, we have restrictions on who can be a witness. So just know them, they're the same ones I mentioned before. If any of you have a living will before 1992, I just wanted to put this out there that the law did change in 92. The living will is still valid, but you may want to reconsider signing a new one. Just if you want life-sustaining procedures to be included with the withholding and withdrawal of life-sustaining nutrition and hydration. You can revoke it at any time, but you do need to communicate that. So what happens if I don't have a living will? If there's no living will, Iowa law provides, under the family consent law, it says that if I don't have a living will, it's first the person in my power of attorney, my attorney in fact, under a healthcare power of attorney. If I don't have one, it's a guardian. But they have to get court order to allow for this. And then, so let's just say I don't have either one of those. It goes to my spouse. Then if I don't have a spouse, it goes to an adult child. If I have 5, 3 have to agree. If I have 2, I'm in trouble if I can't get them to agree. And they're adult children. If I don't have adult children available, that goes to my parents. And if I don't have parents, it goes to an adult brother or sister. So you can see in this situation, I can make my sister go to the top of the line if I name her my attorney in fact, under a power of attorney document. There's also a thing called Ipost. Have any of you heard of that? Okay, a few. Ipost is a physician's order for scope of treatment. It's a relatively new concept. You hear a lot about it in hospitals and nursing homes, assisted living programs. Bottom line is, it's a document that you agree to, but a physician fills out. Usually it's on a really brightly colored page, like pink, hot pink, so that if the paramedics arrive, they can see exactly what it is you want for your health care. It's your document, it goes with you. So if you're in a nursing home, it goes from the nursing home to the hospital. And if you go from the hospital to home, it can go with you there. So it goes with you, it doesn't stay in the medical community. So just know, it gives a clear expression of what your healthcare treatment choices are. And it lets them know, do you have a power of attorney for healthcare? Do you have a living will? Do you have all these other things? So I just want to make you aware of that. I don't know what my time is, Greg. I don't have a watch. Oops, okay. So I'll talk faster. No, kidding. I like to distinguish do not resuscitate, because a lot of people get confused, advanced directives and do not resuscitate. They're 2 different things. Ultimately, they can serve the same purpose, but they're 2 different things. So living will, remember, takes effect when I'm terminal, when I've been diagnosed as terminal, or I'm in an incurable, persistent vegetative state. A do not resuscitate is something, you may have experienced this. If you go into the hospital or you go into a nursing home for some short-term care or stay, they will ask you, do you want to be resuscitated if your heart or breathing stops? If you answer no, you will have, the doctor will sign an order called a do not resuscitate order, and that goes into your medical chart. You do not have to be terminal, right? You don't have to be terminal in that situation. So a do not resuscitate order is simply, if my heart or my breathing stops, I do not want to be resuscitated. All right, so when paramedics see that, well, first of all, paramedics shouldn't be called, right? Because you didn't want it, because if paramedics arrive on the scene, guess what? By law, they have to resuscitate. Unless we have another exception for that, so stay tuned. But anyway, the do not resuscitate is for when a heart or breathing stops. And you don't have to be in a terminal condition to say, I don't want to be resuscitated. I've had people say, I've lived a good life. If my heart stops, it's time. And I've had other people say, do everything possible, right? So I already alluded to the fact that if paramedics are called, they must resuscitate. Well, in 2002, we got this new law. We worked towards getting a new law, which basically says if paramedics arrive on the scene and they see this order or some type of identifier like a bracelet, a pin, or a pendant, they will not have to resuscitate. So you're not in a hospital setting, you're in your own home, but it is a doctor's order. And it says basically to withhold or withdraw outside of a hospital setting. So the DNR does it in a hospital or a nursing home setting. You're out of a hospital, does it outside of a hospital setting, obviously. You have to have the form, the order, and you have to have an identifying bracelet, pendant to show that you have the order. The assumption is you don't have it if they can't find that. And so they will resuscitate. It doesn't affect comfort care or pain medications. So if you're in pain or comfort, they can still make you comfortable. The Department of Public Health, EMS, Bureau of EMS implements this. Your the list of websites has the actual form. So you can go right to their website and get the form. And I've given you their specific website so that you can go download that and talk to your physician about it if that's something of interest to you or a family member or friend. So the key is starting the conversation. Talk about it, talk about it, talk about it. Become that person nobody wants to stand beside because you're going to be talking about it. And then we have the Final Disposition Act, right? So the Final Disposition Act was signed in 2008. What this says, okay, remember the comment that a power of attorney for healthcare cannot make decisions after death, right? Because it terminates at death. What was happening is attorneys, in fact, under healthcare, were getting contacted by funeral homes saying, we need to be able to process this body and we need someone to make a decision. Many attorneys, in fact, were doing that because they didn't realize they couldn't. Sometimes guardians were doing that because they didn't know they couldn't, but they can't either because a guardianship terminates at death as well. So you had this gap situation, right, where nobody was the decision maker, but something needed to be decided. So we now have the Final Disposition Act, which says that you can add to your healthcare power of attorney document a statement that says something to the effect that I want my attorney, in fact, to also make final disposition decisions for me as well. Then it's kind of a seamless. They're not then acting as your attorney in fact after death. They're acting under this capacity, all right? It can also be a separate form. It can be a standalone form as well. But it's the Final Disposition Act. That there is a form on your website, on the website listing, there is a form that's online for this as well. And you can download that and take it to your physician if they are not aware of it as well. But anyway, it's something that you can have at your disposal in your decision-making process. So what happens, let's say, if I don't have this final disposition piece added to my power of attorney, healthcare power of attorney, or have it as a standalone, then the law has provided for who will make that decision. First, it's the designee. It's the person I'm appointing to make those decisions after death. If I haven't done that, it goes to my spouse. If I don't have a spouse, it goes to my children, parents, grandchildren. So now we've added another category here. And so you better talk to them if that's your, unless you want something maybe you don't want, unless you get something you don't want. Siblings, grandparents, if you have them, next of kin. So we're looking for anybody at this point, right? Could be an aunt, uncle, cousin, niece, nephew. Any person that knows you, right? Yeah, it's like, okay, yeah, I met them in a training once. And then at the end of it is your county medical examiner. So that is what the state of Iowa has done for you if you don't do this for yourself. Now, Greg has a case. There's been a case on this specific point in the law, and he's going to tell you about it.
Thank you, Deanna. The case came up at about the time the law was passed, so it was very timely. And this was the second or third statute, the Final Disposition Act, that Deanna and I got to work on together. I can't remember exactly how this would happen, but typically it would go like this. Deanna would either circulate an email or phone call and say, hey, we're putting together a group to talk about this interesting issue. Don't you want to come and be part of it? And I never learned to say no. But the Disposition Act, it came up for a couple of reasons. There was this gap, and then you also had situations, not terribly uncommon in today's world, where you had maybe a second marriage, and so the children of the deceased weren't the children of the surviving spouse, and there would inevitably then maybe be some tension between them about what they wanted done. And so this case came up, and it points out the need for you to make your own decision, but I think I'll talk about the case so you can kind of see how it unfolded. It was an Iowa case, and it was decided in 2013. Our law was passed, I think, in 2012, so it was all happened right together. But the husband and wife lived in Eldora, Iowa. They had 10 children, very prolific family. They moved away and lived in Montana for a number of years. And then the husband moved back to Eldora and the wife stayed in Montana. They were separated, but they never got a divorce. They never filed for separate maintenance. They were married but lived apart. And the mother, I think one of the children may have lived in Montana. That part I don't recall. Then she moved for a while and lived in Santa Fe, Mexico with one of the children. In 2011, she came back for a visit to Eldora, other family members there. And while she was there, she became ill, really too ill to return home. Years before, she had made all sorts of detailed plans about her burial. She had a site, and I'm paraphrasing slightly, but is on a mountaintop overlooking a great vista in Montana, and that's where she wanted to be buried. And she'd gone to great pains to tell lots of people in the family, and she had lots of detailed instructions. This was not just a happenstance thing. While she's in Eldora and she's failing in health, she enlists the help of one of her daughters who lived there in town, and they contacted the local funeral director and said, these are my wishes. What should I do? And unfortunately, the funeral director was not aware of Chapter 144C, and he told her that, well, your husband will make the decisions. And she still gave him the written instructions that were very, very detailed about what she wanted to do. And the practice for many years, the lawyers would do, they would put these instructions in the will. And their theory was that the executor was in charge of everything and they would have a court order to do it. The problem often is that the will doesn't get open a lot of times until after the funeral, and so it would be kind of too late. So, but she had done this in more than one place. She had made it clear to everybody these were her wishes, and then in June of 2012, I believe it was, she passed away. And there was a fight that kind of broke out between the family members. Several members of the family wanted to honor mom's wishes and get her back to Montana where she wanted to be interred. and the husband, the relationship is complicated, like a lot of relationships are complicated. They lived apart. When she was living in Eldora, she was staying in the same home with her husband, not former husband, they were still married, so, and staying with her children back and forth. So they still had a relationship, and he said under the statute, you see, I'm the spouse, I get to call the shots, and there was a hearing on this, and it went to the district court, and the district court said, I think the spouse controls. And then the case went to the Iowa Supreme Court, and the Iowa Supreme Court looked at this, and they went through it, and this is something that you want to think about when people talk about having judges that follow the law. Well, the statute said very clearly that if you want to have one of these statements, you do it in writing, and you attach it to a healthcare power of attorney. That's a condition. That's where it has to be. So while at that time, you couldn't do it as a standalone document. The statute at that time required it to be part of the healthcare power of attorney. And so the Supreme Court looked at that and they said, well, yes, she did do this document in writing, but it doesn't meet the definition of these instructions because it's not attached to a healthcare power of attorney. So the spirit of what she wanted to do was clear, but it didn't follow the technical components. And the fact that it was in her will didn't qualify either because that's not a healthcare power of attorney. Now, the decision of the Supreme Court was a split decision, and there was a dissent, which actually echoed my sentiment on this thing, is that the majority of the court exalted form over substance, that there was clear that this is what she wanted, and everybody knew this is what she wanted, and the fact that she did it in the wrong form should not have penalized so she didn't get what she wanted to have done. So this reinforces the need for you to make the decision yourself and make it clear what you want to have done. One of the things we learned in the process of this, writing the statute, and the perception is that this stuff is done lightly, that our legislature just trots down and they pass these laws and we don't know what they're up to. I bet we met for 2 or 3 years, every couple of months. There would be sometimes 10 or 15 people, sometimes 25 or 30 people, cemetery people, funeral directors, state insurance people, State Department of Health, huge number of people around the table trying to come up with craft this law that worked. And one of the things that we learned is that there's a difference of opinion about who should control. The lawyers view, not universally, but the majority of the lawyers viewed this as say, our client is the person that we're writing the will for, or I'm writing that document for, and if they want their wishes followed, I'm an advocate. In fact, one of the ethical rules that we sign on for when we become lawyers is, and this is what irritates usually the people on the other side, is that we have to be a zealous advocate for our client. When they can't stick up for themselves, we have to do whatever it takes to get the job done, including being a terrible pain in somebody's rear. And so the lawyers believed our client is the one that wanted this, and they're paying for it out of their estate, so they should get what they want. Another view, which has equal weight, and you had to try and balance it, was the funeral directors would say, we're in the business of dealing with grief, and the funeral is as much for the family dealing with that grief as it is for the departed. The departed, to the best of our knowledge, is not there. And so there's this balancing that was taking place, and the statute was drafted with that in mind. But my message to you is, if you have specific wishes, you appoint somebody that will be your zealous advocate to carry out your wishes. A story I tell, which is absolutely true, an older couple that I did work for years, and the husband had a plot of ground that was very special to him, and he always said to his wife, when I die, I want to be cremated, I want my ashes spread under that tree and such and such. And she found that to be just abhorrent. She was not going to do it. The remains needed to be someplace else, not in that idyllic spot where she liked to sit and read. And well, she died first. So he got his wish. Is the bottom line. But the point is, if you have specific wishes, tell somebody, get them down, and then appoint that person or a sequence of persons to carry out your wishes. We stopped intentionally to leave time for questions, and there were some that were sent in, but I don't know where that page went. So, oh, Virginia's got it. We can throw questions out. Yeah.
Quick question. On either financial or healthcare power of attorney, POA paperwork, you happen to mention that they say first this person and if unavailable this person. Is it legally possible to say Jenny or Becky instead of if Jenny, if then Becky? Because when we had this situation in my personal family, Jenny was it because we lived in Chicago and we go visit them in Florida. I was second because I lived here where they lived in the other part of the union. The medical world looked at it and said, well, if Jenny's not available, it must mean she's dead. No, she lives out of state. That's not the deal. So it really took us a long time with the hospital to let them even honor me as power of attorney because I was the second. Is there a way to say or?
So the question, and this comes up a lot, somebody's got 2 children or 3 children and they say, well, I'd like any one of them to be able to make the decision. You have to be extremely careful with your drafting because the language you're talking about where it's got or, you will have, and this is true if it's financial or medical, and it can be equally maddening in each case, the person that's sitting across from you they're thinking about lots of different things. How do I know that that first person is not available? Is this a subterfuge to get around it? Are they trying to take advantage financially? Is there something going on? And so to protect against that, they'll say, I want all of you to sign. I'm not going to take any chances. So my personal preference is not to do or. Make it very clear. I'm naming this person. If they're unavailable or unwilling to serve, then we go to number 2. And you can add conditions to say if they're on a hiking trip in the Tetons, they don't have to do it, but somebody else is. But the more detail you put in it, the less benefit it may be. You want it to be typically fairly general so that the person can serve. But long answer to your question, you can do it, but you got to be very, very careful with the language. You're opening up a kind of a can of worms.
Thank you.
Yeah. Well, you had your hand up while we were talking about something, so yeah, you can go ahead.
You were talking about the guy going in for surgery and the doc says, you want us to resuscitate you. Oh yeah, if something happens, yeah, I do want to wake up. But it sounded kind of like it was an option. You know, you could check, oh no, just let me die, or yeah, resuscitate. But someone whose breathing or respiration stops can't necessarily be resuscitated. They can try, but depending on your overall health, your age, a lot of factors, it would be foolish to try to resuscitate me, for instance, because I probably die of something that'll kill me. Whereas a 12-year-old that falls in a swimming pool for 3 minutes and is unconscious, well, good chance they'll be resuscitated. But me, it's adios. So could you say a few words about, because so often people who have no chance of being resuscitated are.
No, it's a very good question. Can you hear me? Okay. I thought I turned it on, but it's not, didn't seem loud. So you raise a very good point about the do not resuscitate. And it's a question that comes up in many ethics committees of hospitals, nursing homes, within the legal community in general as well, because we can't place judgment on whose life is more important than another, right? As all of the laws that we talked about were for people 18 and over. So the child, that decision would be made by their parents. What the order is, okay, so a do not resuscitate is an order that a doctor signs and puts in your medical chart. You agree to it, however, right? If you have capacity. If you don't, your attorney in fact for healthcare or the guardian can agree to it. Guardian has to get permission from the court to consent to that. But it's a doctor's order. It reads that if my heart or my breathing stops, I do not want to be resuscitated. That is the language. So if you have heartburn, so to speak, with that language, then it's incumbent upon you as the consumer, as the principal, as the person being asked to say, I don't know that I'm comfortable with that, because there's lots of different conditions, kind of like what we talked about with the gift of peace of mind. You know, and if I'm 85, 86, 80, not whatever, or if I'm 20, but I've had a lot of pain, chronic pain, maybe I have a different decision that I want to make. So it's a very difficult balance between allowing someone to make that decision for themselves versus the medical field intervening and not allowing that person to have the choice for themselves. But it's for adults. It is for adults. And the language does read, if my heart or my breathing stops. It's a good conversation piece. I don't know if I answered that clearly, but there's a lot of these things, there's not really good answers. That's why you have to have the communication.
You didn't really address anything like this, but maybe if someone dies, and let's say someone dies in your home, maybe not unexpectedly, but you know they're dead, who do you call?
Ghostbusters.
I like that answer better, but you would also call the county medical examiner or the county.
I'm sorry.
911, you could call 911. They'll make sure to get the right people out.
I'm sorry, I didn't mean to be flip. Go ahead.
That was funny though.
All the way in the back, you had your hand up.
Deanna,
Yes,
may I have you clarify
yes, I'll
something
try.
here? When you were talking about the healthcare power of attorney, you said you can change it at any time, as long as you're of sound mind and capable, I assume.
You don't.
You don't. You said, here I am with my doctor, and I decide I'm going to change my mind because I don't like what my son Kevin is telling the doctor to do. But the document itself says this power exists only when I am unable, in the judgment of my attending physician, to make these healthcare decisions. So there's no healthcare power of attorney in effect when I'm capable of even changing my mind about the healthcare power.
Right. You are correct, and you are not losing your mind. You are capable. So here's the weird little kick. So you are correct. To sign a power of attorney for healthcare, you have to have capacity. To have it take effect, your doctor says you don't have capacity to make those healthcare decisions. The law also then says to revoke a power of attorney, you can do so regardless to your capacity. So I can be in the midst of receiving care regardless of my capacity, and I can revoke a power of attorney for healthcare.
Is that a little tiny, like, error leak?
It's not an error. I think what was happening, and Greg, you may speak to it as well if you feel comfortable, but okay, if he's not, I will. I like to share opportunity.
Take a stab at it. If there is some tiny bit of capacity that you still retain, the law wanted to give you a chance to still exercise your will. So you might have, and this is the thing about it, and we all know circumstances. Okay, the day you sign this document, you're completely with it. You have an episode of illness or a stroke or something, and you're out of it, but you're recovering and you're coming back. Doctors dealing with your son or daughter who's got the agency to make these decisions, and you're gradually coming back, and one day you're pretty much with it, and you don't like the source of treatment, and you speak up and say, I don't like that, I'm firing you as my agent. This is an example. And I've lived this one time with a dear friend of mine who was an administrator of a care facility where the niece was admitting her aunt to the facility, and the aunt was asleep basically in the chair and woke up and said, what are we doing here? And the niece said, well, we're admitting you. We've been talking about this for weeks. They'd sold her house. She had no place to go back to. And the aunt said, I'm not staying. Take me out of here. And the niece, in frustration, she didn't need to do this, but in frustration, she said, well, Auntie, I'm using my power of attorney. I'm signing in anyway. And the aunt, who had that little bit of capacity left, said, you know what? You're fired. You're my agent. No longer. So here's my friend who's the administrator of this facility. He goes, I had a power of attorney, was about to sign her in, and now I don't have one, and this lady is not staying, so I can't admit her. So this is the give and take that goes with it, and you have that, just that shred of capacity.
And the other piece I'd add to that is capacity is fluid. So I can have, today might not be a very good day for me, but maybe tomorrow is. And so that's another distinction.
Ron, do you have one?
I can speak, I think, loudly enough, hopefully. What about this pink sheet, the Ipost? People carry those around with them?
Not
And I'm
generally.
driving my little Miata along and I get hit by a garbage truck. Okay? And what I'm laying there fumbling for my pink sheet while they're trying to determine what to do.
You don't want the pink sheet at that point. So this is what the form looks like. It doesn't have the forms attached. What you might want to have in your wallet or in your glove compartment box or in your car is a copy of your durable power of attorney for healthcare or a living will. This isn't going to tell paramedics that it just says I have them, but it doesn't show them the document. Right? So this is a kind of a cheat sheet for people in a hospital or a long-term care setting, so that at a glance, medical professionals can see what you have.
So if you're admitted somewhere, they have that, but it's not if you're coming in off the street.
Generally speaking, that is correct.
One of the things that we will recommend with the healthcare power of attorney and the living will is that we have a wallet card we give people so that it alerts them to the fact that there is one and who should be called. So if the medical staff is giving you treatment, they're checking your ID, they say, oh, this son who lives in West Des Moines should be called, and then that person shows up with the document. There's no perfect way, but you should get it to your treating physicians and to whoever.
There's some people who contact the hospitals if they go to a specific hospital and they have it on record. So if they're brought to that hospital, they know. Yeah.
Look at those hands go up.
This one here in purple.
Okay.
I'm a librarian, and I had a situation where someone came up to me and wanted to know who do they contact, because she had given over power of attorney to someone who was not really doing what she felt she should be doing for her father. And I didn't know who she could go to. I suggested, legal aid, because I didn't know who to send her to. But I was just curious, because if she wasn't even allowed to see her father, or even to speak with him, and she didn't know that was going to happen when she signed that power of attorney over to that person. And so you had mentioned that there is someone that you can challenge it, but who does she go to?
So this is a daughter that's being denied access to her father, it sounds like. She's probably going to end up filing a lawsuit against the agent to say that she's abusing her power as a power of attorney. And then the court's going to evaluate what she's doing to see if it's appropriate.
But if she doesn't qualify for legal aid, then what? Does she have to go to just a lawyer?
Yes.
Yes. There is a protective order, but that's only going to protect the person. There's an elder abuse law where someone can file a protective order to help themselves, but I don't know that, and it does say or interested person. So the daughter could go in and file the protective order under the elder abuse law. Anthony, you remember the number? What? 235F. Thank you. It's under Iowa Code 235F. There is an order, there's a process through the court where you can file for a protective order, either the person that's impacted or the person who's an interested party. The other piece I would throw out there is talk to your area agencies on aging. They generally have an elder abuse type of a coordinator or someone who can answer questions. Dependent adult abuse is what we have in Iowa. So DHS, Department of Human Services, might be another option if we show the person's a dependent adult and it's their caretaker that's neglecting them.
I think she mentioned DHS and said that they told her, well, you signed it over, so there's nothing you can do now.
We have a whole lot of education to do.
Well, and I want to be careful about how I answer it, because it sounds like the original document named the daughter, And it says she signed it over. Well, she didn't sign anything over. She might have declined to serve, and that put the next person in the alternate in place.
Right, I don't know if it was signing or
Yeah.
declining, it could have been either,
But-
yeah.
So she doesn't have the power to give it to anyone else. That only belonged to her father. And that we hear about cases like this periodically, and then people regret that they've surrendered that power, which is
Because
what it sounds like.
she acted as if she was talked into it. And then after she was talked into it, wished she hadn't done it.
You could also call the Bar Association because there's a lawyer referral system. There's also someone that can help get you to the right resources as well.
And in Polk County, I mean, we're really fortunate because in addition to the bar being here and you have the lawyer referral service, you also have legal aid, which you mentioned, and the Drake Legal Clinic, which does terrific work. It's second and third year law students who are supervised by practicing lawyers. And I don't know exactly what the criteria is for the cases they take, but they do really good work. All of those offices do good work. There was a question over here, and you've been very patient, ma'am. Virginia, you really jumping around back there.
Early on, you mentioned that you too had worked with something called the Office of Substitute Decision Maker. I just wanted to know if that still exists and what it does.
So it does exist. It's through the Department on Aging. They changed their name this last legislative session. I think it's called the Office of Public Guardian now. And what they do is they can serve as a guardian of last resort for people. So if someone is truly in need of a guardian, but they have no one, or the person that they do have is inappropriate, that office can be appointed. They've also contracted with people around the state. So there's a local presence that can step up and serve as a guardian. But that's their sole main focus, as I understand it now. Yes, sir.
Are power of attorney agents responsible, financially culpable for the decisions they're making on the behalf of the principal?
So the question is, are they financially liable for the decisions they make? In theory, yeah.
If they're not acting in the best interests or carrying out the wishes of the person that they've been assigned to serve.
Well, let's say a principal goes broke, or whatever, if you just spent $3 million on medical treatment, then the chance to survive. Is the agent on the hook for $3 million?
Well, so the question is, if they spend all the money on medical care for the principal, and then they are broke, as long as the money was spent in good faith and in the best interest of the individual, I don't know that there's going to be any liability. If, you know, the cases that are a little more clear cut is if that person pocketed the $3 million and then applies for Medicaid for the principal and says, look, they're broke. Now that agent is probably in trouble. But if they're doing something for the best interest of the individual, they don't probably have any liability. The question is, what's in their best interest?
And I think it goes back, regardless of the liability question, it goes back to the communication. You know, if I don't want $3 million spent on my health care, I probably need to communicate that at some level, if at all possible. The hard part is we can never predict every circumstance that's going to arise. What are your goals?
Yeah, what we encourage people, if one family member, so one son or daughter is serving as that agent under a financial power of attorney and there's other children, the scenario that we see occur all the time is that they've been serving as that agent for 3 or 4 years and then mom or dad dies or they go to the care facility and the other kids are there helping clean up the house and they say, well, you know, when are we going to get our share? And they say, well, the money's been spent. And they say, what do you mean they've spent? They had $500,000 5 years ago. Well, they spent $80,000 a year at the care facility and the money's gone. And what I will say to people, if you're serving in that role, communication, as Deanna's mentioned, is the key. At least once a year, send a report to them. This is where we started. We had expenses. This is what we're spending on. And if somebody's going to have heartburn, let's get it out now. We can go to court and get somebody else appointed if you want to. But communicate what you're doing so that you don't get accused at the end of the day for doing something you shouldn't have. That's not perfect. And we have principals who say to us, I want my son to do this and I don't want the rest of the family to know anything about it. That's not uncommon for Iowans. We like to keep things close to the vest. And if that's what they want, that's what we have to do, but. Yes,
You
ma'am.
had,
Yeah,
Iowa Hawkeye guy.
yeah, you've got the mic too.
Thank you. Every time they come anywhere near the medical profession, one of their standard questions is, do you have all these forms that you talked about? Can they be presented as needed? The hospital have to accept them at that time, or should they be presented ahead of time?
Good question. So they will ask, because there was a law called the Patient Self-Determination Act, where they had to start asking people if they had these advanced directive type documents. I think what I would recommend is talk to the hospital and see what's easiest for them. Is their system capable of inputting or scanning those documents? Most systems are now. But is the system capable of having the document scanned and having it in your record so if upon admission they can see it? Or would they prefer to have you bring it in every time? So I would ask if there's a specific hospital you like to go to or frequent for your health care, I would ask them that question. What's most convenient for them?
More and more people, I wouldn't say it's a majority yet, but more and more people, because of so much you can carry on your smartphone, will load it and have it on their phones. And so when they're being admitted, they can show it to them, they can email it or forward it to them right there on the spot. And a lot of facilities will take it and load it into their system. But it still amazes me in this day of computers that you'll go from this desk at admitting to this desk at surgical input, and you have to tell them the same thing. But part of that is to verify that you know where you are, I think. But
on the durable power of attorney for the financial part of it, can the principal use the microphone? Okay, on the financial power of attorney, can the principal stipulate that the person who takes the power of attorney gets paid? Are you allowed to pay them a certain amount? Is there a certain percentage, or?
you can allow for compensation, and it is actually a job. There's no set fee schedule. If you have not put anything in there, there's a presumption that you're doing it because you're doing it out of the goodness of your heart. There's a danger, of course, when you put compensation there, is who's setting the limit. And if you leave it to that agent, the fear that a person has is that they might take advantage of it. This goes back again to, are you going to appoint somebody that's going to do that sort of thing? But I'm not aware of any place you can find a scale that tells you what it ought to be. We tell people to be very, very careful if they're paying themselves a compensation.
I think we've got a couple minutes, and then at least for all of you, I want to be cognizant of your time.
If you stay late, you get extra credit. You'll be on your waiting.
Well, you can have a form signed.
Will copies be accepted, or do you have to produce the original signed document?
My experience has been copies are accepted. Mm-hmm. You had your hand up. Yes, go ahead.
I'd like you to, thank you. I'd just like to make a comment about the daughter who couldn't see dad. It could be also, families get literally nuts when somebody's dying, and it could very well be that there were some real complications with that DPOA, and it could be the old man said, I don't want my daughter in here anymore. She's been nothing but trouble all my life. I'm done with her. But she's got unfinished business. Mm-hmm. So it's really hard to tell what's in people's best interest. Now, the question I'd like to ask is, what about dialing back healthcare? I have a heart attack. I don't want extraordinary efforts made to prolong my life. But if I'm having a heart attack and they can give me some medicine, I can go home in a couple of days and be okay and live for 10 more years. But then how do you say, okay, now he's too far gone, let's just quit. Getting something going and escalating is a lot easier than just stopping a treatment or a therapy or a hospital or a doctor.
Well, life-sustaining procedures does infer that if a procedure has been started, it can be withdrawn. But you are correct, it's a little more difficult because we want to make sure that is the way to proceed because of liability. Kay, did you have something to that?
I just wondered, no, I'm sorry.
Okay.
In relation to that, I was just wondering, who
should have the original? Do you think,
I would say the principal, who's the person who signed it, but there are different opinions about that.
And in our office, we offer to hold them for people just in safekeeping, but they belong to the individual. And we do that just so the family knows where they are, and if they need a copy, we can shoot them to them wherever they are. But yeah.
And I don't want to lose his question, but yeah, go ahead.
One thing, somebody brought up here this uncomfortable situation.
Mm-hmm.
Thank you, Virginia. Someone in a question here brought up what I would see as a really uncomfortable situation where the medical power of attorney, not the medical power, the medical attorney in fact for healthcare decisions is making decisions on my behalf that are going to cost money.
Yeah.
Well, my financial attorney in fact is a different person.
That's correct.
Okay, so we perhaps have some potential conflict here. How does that resolve in the real world?
Go ahead, Greg.
One of the things I would tell you is that while one of our ethics is to be a zealous advocate, there are an awful lot of us that have been trained to be mediators. And our title a lot of times is attorney and counselor. And so we're trying to work with these people who have different views to see if we can't find common ground to reach what's the best interest of that individual. If you can, great. Sometimes you cannot, in which case what will likely happen, and I have one almost exactly like you're describing right now that I'm working on, and we're making some headway, but the backstop is going to be if we can't get it resolved, somebody's going to file an application to be appointed as a guardian and conservator so that that court-appointed person would take precedence. Now, our law says clearly that the healthcare power of attorney trumps a guardian unless there's evidence that that person's not working in the best interest of the individual. But a conservator, the financial person, can be appointed by the court and it will override a financial power of attorney. And a judge, because that's their job is to make those decisions, they'll make the decision. May not be the one that you would have chosen, but they will break the tie. Yeah.
Well, I know we are
Did we
at
answer-
time. Oh,
did we
I don't know
answer-
if we got really back to your question as well.
About
Yes, you did. Thank you.
a point I would make in
Good.
response to it, and it's there was a lawyer that used to write a magazine column that I read very religiously, and he talked about a story of a longtime client of his who he had done all the advance directives for years, and she called him to come visit him. She was recovering from an episode of some kind in the hospital, and they'd known each other for years. And so he said, I got up there to see her, and she wanted to know about my kids. And they talked for half an hour about other stuff. And he finally says, why did you call me up here? What's on your mind? And she said, I want to talk about the healthcare power of attorney. And he said, well, you're glad you had it, because she'd been adamant that she didn't want any life-sustaining procedures. And she'd reached maybe 75 to 80 years of age, which years ago I used to think is older, and I don't think that that's old at all anymore.
It's not.
But she was a little older than he, and she said, you know, now that I have had an episode, and even though I have limited abilities compared to what I used to have, I'd rather stay alive, and I don't want the same answers today that I wanted 5 years ago. I might be a lesser quality that I perceive, but it's still what I want. Kay,
that booklet, the 5 wishes, which you can look
Yeah.
up on the internet, is Google 5 wishes. It's kind of a really nice guide too to go through.
Very good point. Very good point. Well, I think we are at our time. We appreciate all of your energy and your questions and your attention. Thank you for attending. We'll be here for a few minutes if you have questions, but otherwise look forward to the next.
Thank you so much.